my three other panelists for today?
We're doing well. I'm doing well, at least. I don't know how everyone else is doing.
I got a thumbs up from Mark. I got a smile from Pedro. Everything looks good. All right, so it is 5 o'clock. Let's make a start. So, everyone viewing on both YouTube and Zoom, welcome to Family Law Now After Hours. Today's topic is Parents' Guide to Child Support. This is definitely a topic that's one of our most viewed, one of our most recommended in terms of requesting. Child support is a really heavy and comprehensive topic, so we're all definitely going to do our best today to help dive in, answer any questions you may have, dive into the big topics. I'm sure each one of our subtopics we can spend an hour itself talking about, so we're going to do our best to condense everything into 1 hour for everyone today. Um, Child support does exist, and it does meet the needs or at least ensures that the children continue to benefit from the financial resources of both parents after separation. That's the goal. That's the reason why it's there. And in Ontario and Canada generally, child support is typically calculated using, the federal guidelines. If you are a married spouse, then we use the federal guidelines. If you are common law with a child, we use the Ontario guidelines, but they're very similar. And what we look at is, the guidelines provide table amounts and rules for additional expenses, which we'll get into today and discuss, and really understanding how the basic amount and extra costs, which we describe as Section 7 expenses, are calculated, who pays and how payments are enforced will definitely help parents protect their children's needs, as well as avoid costly disputes. So if you are joining us via Zoom today, you are invited to use the Q&A feature to submit your general comments or questions about, the topic that we're discussing today. For specific questions about the details of your family law matter, please do contact our team directly. We won't be answering any fact-specific questions or comments posted, as well as any other comments or questions about topics that we are not discussing today. Unfortunately, if you are joining us via YouTube, you won't have that option. So moving forward, if you do want to be able to participate and ask questions, feel free to register for the Zoom invite. The purpose of this series, Family Law, Now After Hours, is to discuss general information on separation, divorce, and family law matters, and any information provided here should not be construed as legal advice. Stay tuned until the end, as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at the firm. Now, to introduce our panelists for today, with nearly 9 years of experience in family law, including 2 years as a family law clerk here at the firm, Sonia brings a wealth of experience to her role. She specializes in various aspects of family law, such as case research, document preparation, court proceedings, and client relations. Recently licensed to practice law in Ontario, Sonia now serves as an associate lawyer here at the firm, aiming to leverage her legal knowledge to provide exceptional support to clients. Known for her upbeat and optimistic demeanor, Sonia prioritizes building positive and trustworthy relationships with clients to alleviate the stress associated with domestic issues. We also have Mr. Aguilera. Pedro joined the firm in September 2022 after working at a small practice in Toronto. He helps clients and their families navigate the legal process, whether through virtual meetings, managing filings, or reviewing court documents. Pedro earned a bachelor's degree in political science from York University and later pursued a master's in human rights and multi-level governance at the University of Padova. There we go, in Italy. Born in Havana, Cuba, and having lived most of his life in Canada, Pedro has a unique perspective on the importance of judicial independence and access to justice. He values Russell Alexander's innovative use of technology to make legal services more efficient and accessible while giving him the flexibility to pursue his passion for helping others. Mr. Mark Simpson on your screen as well is an associate lawyer at Russell Alexander, and he guides clients through family law with solutions that save time and resources. He previously ran his own practice, gaining experience in trials, mediations, and arbitrations, and now serves as principal to the firm's articling student. Mark is a father of three teenage boys, coach certified with up to U13 designations of the Ontario Baseball Association, and enjoys mentoring. He's also served on the Hamilton Road Business Improvement Association Board. And outside of work, he serves on the Middlesex Law Association and Oak Ridge Optimist baseball boards, as well as pursues his passion for health and fitness. Last but not least is myself. I am a compassionate family lawyer who is driven by a deep desire to support families through challenging times. With a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. During my articling period, I gained confidence in handling a wide range of family law matters. I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am also certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs as well as LA Rams fan and enjoy playing hockey and watching comedy movies. So, with that, introductions being done, um, panelists, Pedro, Sonia, Mark, thank you so much for taking the time out of your day to really inform the public about such a pressing and important issue, that being child support. So, with that, I'd like to jump right in to our topic for today, Parents' Guide to Child Support. And Sonia, I'm going to bring it to you first. Maybe you can explain to our viewers today, really. I know I sort of touched on it previously in my introduction, but if you can really dive into the purpose and importance of child support.
Yes, absolutely. I'm just going to generalize it and simplify it for a lot of viewers may not really understand. So, generally speaking, the purpose of child support is designed to ensure that a child of the relationship is financially stable post separation. Okay. So, it's meant to cover the costs of the child's basic needs and everyday needs, such as food, shelter, clothing, and is geared to ensure that the child maintains the same standard of living that both parents have provided to the child prior to separation. Depending on the parenting arrangement that has been agreed upon by the parties, child support can be paid by either one parent directly to the other, or it can be shared by both parents as an offset to child support. Child support is ultimately for the benefit of the child, and there is a legal obligation to pay child support, even if one parent does not necessarily agree or want to pay. So, to be clear, child support is a legal right of the child, not the parents, which is why there are child support guidelines to follow, which outline exactly how much one parent or both parents are to pay per month. And these guidelines consider such things as the payer's income, the number of children, and even the age of the children being under the age of majority. And the objectives of the guidelines are to establish a fair standard of support for the children and to ensure that the benefit of the financial means of the parents, in the case of divorce, financial means being divorced parents. It also helps to reduce conflict between the parents. It helps to improve the efficiency of the legal process generally. And it also ensures consistent treatment of the parents and their children to maintain a stable relationship. If you are legally married here in Ontario, here in Canada, and you are seeking a divorce under the Divorce Act, you would be pursuing the federal child support guidelines. If you are not legally married and want to separate and claim child support under the Family Law Act, you will need to refer to the provincial Ontario child support guidelines. And Joseph, as you stated, although these are not the same, they are very similar. And we have Mark next up to explain how child support is calculated here in Ontario.
Sonia, you're taking my lines here. No, very, very well said. I think, bottom line is that the purpose of child support is to ensure that, depending on where the child is residing, there is somewhat of an equal standard of care, and the parent who is earning less than the payor parent can still provide the necessary standard of living as noted by what the government notes. Whether or not that amount is enough is one thing. The guidelines were recently revised. However, again, with cost of living, the government dictates to us as lawyers what the appropriate amount is. Again, and Sonia mentioned, but Mark's going to expand on is really how child support is calculated. So, Mark, the floor is yours.
Thank you, Joseph. Well done, Sonia. Um, how child support is calculated in Ontario. We would refer to, as Sonia pointed out, the existence of the guidelines assists us on guiding us as far as the specified information that we may use. Section 15 and 16 of the guidelines refers us to using the previous year's T1 individual income tax return, specifically line 1500. It is a guideline. We are to look at the information and inputs into the tax return from line 10100 to 1500. May be a number of sources of income that may be needed to be taken into consideration. If it's rental income, business income, self-employment income, pension income, all types of sources of income. In addition, we have section 19, which refers to imputing income. So if we were to be dealing with a situation of where income is being earned or could be earned, but does not demonstrated on the tax return or reflected at line 1500, that all forms part of that first step to determine what is the child support payor's income. To further delve in to what that means, any of the counsel at Russell Alexander would be pleased to assist in your circumstances. The next step is the number of children in the situation. And we need to know that so that when we turn to Schedule 1, appended to the child support guidelines, we can look in the appropriate columns after determining, again, the child support payor's income and the number of corresponding children for whom the child support payor should be paying child support, as pointed out by Sonia. Well done. We can then determine and establish the table amount of child support that the child support payor is to pay. This does not end our analysis, as sections 8, which deal with situations of split custody, where one or more children are with one parent and one or more children are with another parent, or shared custody, where said children may be spending 40% of the time or more over the course of the calendar year with both or more than both children, parents, my apologies. If we are in a situation of shared parenting arrangements, i.e., we've crossed the threshold of 40% of the time for the children being with each parent, then there would be two child support payors. As you can see, the matter can be, despite the purpose of the guidelines being to simplify things, can get quite complex, and it's always advantageous to consult with any of the lawyers through our intake department at Russell Alexander. Once we've established the child support payors, who they are, what their income is, what the parenting arrangements are, we can then consider the commencement date of the child support payments. I'm addressing how child support is being paid, but other considerations would be when it is to be paid. As a default, it is to be paid from the date of separation going forward. If you do not pay child support commencing from the date of separation on an ongoing basis, and you eventually find yourself in a court matter, you will be paying child support from the date of separation, except in very rare circumstances of where that gets um, washed into the negotiations. However, that is not something that can be bargained away because the child support is the right of the child. So, how child support is to be calculated, we receive our guidance from the child support guidelines, and I think subject to other considerations or adjustments, such as Section 10, which deals with undue hardship. There's a section in the child support guidelines, I think it's section 4 or 5, which deals with income over 150,000. You can just well forget that section because it doesn't really apply in cases that I've seen in my experience. We have averaging of income under section 17 and corporate income for shareholders and whatnot under section 18. But I think that would touch upon most of the aspects on that issue about how child support is calculated.
Thanks, Mark. Very, very comprehensive as always. And a bunch of questions coming in. I'm going to summarize them as best I can into one big question because I know this is often on everyone's minds and people don't like hearing the answer. However, as lawyers, we provide realistic, practical legal advice. So the questions that we are getting, again, I'm going to comprise them into one big question, is that if you do not agree with the parenting time schedule post date of separation, are you still liable for child support? And Mark's unmute. He's muted and he's mouthing yes, but I'll let him speak to that.
Yes, child support is the right of the child. It is not related to a parent's even unilateral decision in establishing a parenting arrangement. Those arguments are best left for the dispute as it relates to what the parenting arrangements are. That goes to a de facto or de jure status quo for parenting arrangements if there is or isn't a status quo. But the even the unilateral parenting time arrangements is not going to impact the items that need to be paid for, as outlined by Sonia: food, clothing, shelter, all still needs to be paid for.
Mhm.
It's not something that the courts or collaborative lawyers or mediators are going to spend time to do to unravel why or how the parenting arrangements after separation ended up the way they did so that they can determine child support. It's not fair to the children for them to go without food, clothing, and shelter while we're determining how it is that the post-separation parenting time arrangements came about.
Well answered. Thank you, sir. And Mark dived into, how child support is calculated, the various forms of income, whether it's business income, whether one's earns dividends or investment income, they're a T4 employee, so on and so forth. But Sonia, for the purposes of, determining parental incomes, now that we know how it's calculated, how are we making a determination on what an individual's income is, and I guess also in relation to their noted expenses as well.
Right, right. So basically, to figure out how much child support is owed, the first step would be to determine the payer's yearly income. So we would regularly seek the previous year's notice of assessment, income tax returns issued by the CRA, and also pay stubs. Now, to dive deeper, what we really want to do is we want to obtain the last 3 years of income and recent pay stub, and if self-employed, a financial statement for your corporation. We're essentially want to calculate the annual income for support. We want to add up the income, subtract the deductions, and add back in any other annual income for child support purposes. Um, if there's any fluctuations in income for whatever reason, such as commissions or bonuses, uh, we want to average those out in over the 3 year period to get a more stable figure. Essentially, that's what we're trying to do. Um, so that would be the very first step. And most family lawyers or sorry, family law firms will have a divorce mate program, which assesses, or sorry, which will assist all lawyers in the preparation of support calculations. And this takes into consideration the factors that we've already considered above to determine support. I'm not going to talk about the income over 150K because Mark already explained that. So we're not going to go into that detail. But essentially, what we're doing is we're trying to determine the exact figure of the payer's income. Once we determine that, we would know, roughly, not roughly, exactly how much child support ongoing monthly would be paid from the payor to the payee. The other thing to consider is something called, in addition to the monthly ongoing child support, is something called the special and extraordinary expenses, or as most family lawyers like to call it, Section 7 expenses, because it is Section 7 of the guidelines. I know that Pedro will be going into detail specifically about all that, but I do want to just explain that these expenses are related to the child's best interests. Um, I'm just going to, he's probably like, Pedro's like, no, don't say anything, but I just want to just briefly touch upon it. It relates to such thing as childcare, health related expenses, extracurricular activities, and depending on the arrangement that you have, the parenting arrangement, sorry, not the parenting, depending on the arrangement that you have with your ex-spouse or your ex-partner, they could be paid either 50-50 split or proportionate to your income. So each party's income. So like 60-40 or 70-30 or whatever the case may be. Um, so yeah. So I don't know if I missed anything.
No,
Probably did.
I think you hit all the necessary topics. I guess again, we could speak an
Yeah.
hour just on determining income. I mean, just one thing I'd like to add is that um, it's relatively straightforward when we have a T4 employee and we're looking to determine income for purposes of support. Things get a little bit trickier when, we have a individual who maybe has a sole proprietorship or they work through a corporation and, that calculation method does become a little bit more intense, quote unquote. And really, that's when us as family lawyers, our job is to know the law and to advise our clients on how to move forward on certain legal issues. But what we don't do is we don't really get into the nitty-gritty financial aspects of doing certain calculations. And that's where we tip our hat to various other professionals, such as financial professionals, whether that be CPAs, CFAs, actuaries, and they produce reports, for example, such as a guidelines income report. And that actually allows us to look at, from a third party perspective, what an individual should be earning, or at least is earning, if they are, again, not a T4 employee. So those are different avenues that we look at when needing to determine income. But we are going to move now to our next topic, and that's going to be discussed by Mr. Aguilera. So go ahead, Pedro, take it away.
Good evening, Joseph. So tonight I'm going to chat a bit about the two main types of child support payments we see most often in Ontario. That's the table child support and the set-off child support. These two depend mainly on how much time each parent spends with the child and on their respective incomes. So let's start with the basics. Table child support is the standard model, the one we see in most cases. It applies when one parent has the child primarily in their care, meaning more than 60% of the time. In that situation, the other parent, the one with less parenting time, pays support based on their income and the number of children, following, as we have discussed already, the federal child support guidelines. Now, the amount isn't really negotiable, as this is set out once again in the official child support tables, which anyone can look up online. Now, child support is meant to cover all the ordinary day-to-day things. We're talking mainly about housing, food, clothes, Now, one thing I see quite often is that parents try to negotiate that number down. They will say, well, I'm already buying clothes, or I pay for the grocery when the child is with me. But under the law, the table amount is presumed to be correct. The idea is that table child support keeps things consistent and predictable. Same income, same number of kids, same amount, no matter who you are or where you live in Ontario. Now, let's look at the other type of support, the set of child support. Set of child support comes into play when there is shared parenting, meaning each parent has the child at least 40% of the time. That 40% is a key number. Once both parents reach that threshold, support is calculated differently. So let's look at how is that so. So what happens is that each parent owes child support based on their income. We then compare the amounts, and the parent who owes more pays the difference. That's called set of child support. So, but let me give you a concrete example if I wasn't clear enough. If mom earns, let's say, 80,000 and dad earns, let's say, 50,000, they share time equally and they share time equally with one child. Mom's table amount may be around 750 roughly, while dad's may be around 450. So the difference, the $300 a month difference, is what mom should pay dad. The logic is simple. Both parents are spending money when the child is with them. So we balance things out so that the child has similar standard of living in both homes, in both households. So, and that's something important to remember, that equal time doesn't automatically mean no child support. So in conclusion, and again, as I told you, I was going to be brief. Table child support applies when one parent has the child most of the time and the other pays the full guideline amount. That's table child support. And set of child support applies when both parents have shared at least 40% of the time and only the difference between the guidelines amount is paid. At the end of the day, both systems have the same goal. And this is something that all parents should understand, which is to make sure that the children are supported in both homes fairly, consistently, and based on real numbers, not assumptions. Back to you, Joseph.
No, thank you, Pedro. Very in depth and a great explanation. So I'm now going to turn to our next subtopic. Basically, another after people realize the first question, A, do I have to pay support? And B, how much do I have to pay? The third question that I'm sure Sonia, Pedro, and Mark can agree to is the next question along the lines of what's asked next is how long do I have to pay support for? So I'm going to be discussing that, and I'll be discussing, how long child support lasts and really when it can be modified. And really understanding this ensures that the children's needs are met while also reflecting the changing circumstances of parents. Because again, things are not stagnant, especially with children. There's circumstances are continuously changing. So child support is reflective of that. So, with respects to the duration of child support, in Ontario, and we're going to be focusing primarily on Ontario, but this, does apply to all of Canada as family law is both, federally and provincially regulated. Um, Child support generally continues until the child reaches, as Sonia mentioned, the age of majority, which is 18 years old. And support can continue beyond 18 if the child is still dependent, and that's either due to full-time post-secondary education, so that means they're enrolled full-time at a college or university, they're getting their diploma, they're getting their bachelor's degree, or they have a disability that prevents self-support. And that's usually something that's a long-lasting illness. Some examples can be forms of autism or any type of illness that prevents them from being self-dependent and independent themselves. And courts will consider whether continued support is reasonable and necessary to meet the child's needs. And again, the factors that affect duration with respects to education and training. So, as I mentioned, so post-secondary education may extend support obligations. It cannot be part-time, it must be full-time in school. That's really the key there. They have to be full-time enrolled. Again, going back to the disability or special needs of the child, depending again on the type of disability or special needs. Obviously, if it is a interim or short-term disability, for example, as a result of a surgery the child may have had or the children may have had, support is extended to the time in which they are able to be independent. However, again, if it is a special need, that's a lifelong disability, a lifelong illness, that may extend support indefinitely. There are parent arrangements that can set duration post the age of majority, and that's usually discussed between counsel in terms of either negotiations outside of court with respects to whether or not support can be extended maybe to a second degree or even a third degree, or if they want to get a professional degree. Like there's ways in which child support can be negotiated for a further period of time. However, the law is quite clear in which it outlines when a child ceases to be deemed dependent or not. Um, with respects to the modification of support, a parent can apply to modify support if there is what's called a material change in circumstances. And a material change in circumstances can be anything from change in income, whether that's because a parent retires, whether they earn either less or more the following year, as well as the child's living arrangements. If there's changes to that, maybe one parent did have primary care and due for whatever circumstances may have unfolded, now the other parent is now the primary caregiver. So that's going to impact or a need for a modification or a varying in support. As well as, again, modifications can increase, decrease, or terminate support as circumstances dictate. So that's also very important to keep in mind. Um, with respects to both retroactive and prospective changes, courts may order retroactive support. Um, there is a lot of case law to suggest how far back retroactive support can go. We have a most recent case in the Supreme Court of Canada, which references a 3-year period in which you can go backwards for what's known as retroactive support. However, there's lots of factors that come into play, whether the 3 years is appropriate or not, but we're not going to be discussing that in today's webinar. But if a parent is entitled via their child or in respect of their child to higher support, that's something a court's going to look at. It's also going to look at whether or not there was a prior written agreement. So whether there was a domestic contract, such as a separation agreement, that details how support is to be varied or modified on an ongoing basis. More often than not, both in separation agreements as well as court orders, there are clauses dealing with the yearly modification of child support, both the table amount, as Pedro mentioned, as well as the proportionate sharing of Section 7 expenses. And child support is to be reflective on the current incomes of the parties or the parents. And as such, there are clauses in place, whether that be, and again, a court order or a written agreement. And even if there is no clauses in the written agreement or court order, legislatively, there is an obligation to modify support based on current income. So that's is to be done on a yearly basis. And if I can just give some practical advice before I close off this subsection, it's really important to keep accurate records of income, expenses, and changes in the child's or children's needs. And again, you don't need lawyers to do this per se. Um, there are people who have separation agreements or they have court orders who are very capable of working together collaboratively, amicably to vary child support on a yearly basis. So if you are able to communicate promptly with the other parent and do so on an amicable and collaborative matter, that's great. But we would suggest, or at least I would suggest, and I know I'm sure Pedro, Mark, and Sonia will agree that you should be seeking legal advice before making changes to support. That's, it's really, really important. And, again, this goes without saying that child support is not static, right? It's designed to adapt to the changing needs of children and the circumstances of parents. And it's really important that you're staying informed and being proactive. And this will help, avoid disputes and ensure fairness for everyone involved. So with that, I am now going to turn it to Mark. We've discussed, how child support is calculated, how long it's to last, how we can modify it, and, how it's done usually on a yearly basis, just specifically in relation to table and Section 7 expenses and the proportionate sharing of those. But Mark, how do we enforce these support orders?
That's an excellent question, Joseph. Um, Enforcement mechanisms, I would suggest to start with the Family Responsibility Support Arrears Enforcement Act and look at Section 1, which defines a support order, which definition includes reference to a domestic contract, including a separation agreement. I would also suggest that we look at Section 35 of the Family Law Act, which allows for the filing for purposes of registering a separation agreement for enforcement, filing a separation agreement with the Superior Court of Justice or Superior Court of Justice Family Court branch, whichever is applicable in your jurisdiction, the viewer's jurisdiction, for purposes of enforcing the separation agreement through the Family Responsibility Office. So what I'm saying is, if two spouses have separated and they have a written separation agreement, domestic contract, which is the same thing. I apologize for being wordy. I am a lawyer. The way to enforce it is by those two sections. It's acknowledged or recognized to be in order, and to register the agreement through Section 35 of the FLA, the Family Law Act, it would then be processed through the Family Responsibility Office for enforcement purposes. The key, I don't know how clear I've been. The key at this point is there's mechanisms in place that allow the registration of the agreement for enforcement with the Family Responsibility Office. Let's stop there. If we have a separation agreement and we do not wish to go through the enforcement by way of Family Responsibility Office, then that separation agreement is not going to be recognized as a court order. If you have, on the other hand, if you have a court order that which automatically is going to be registered with the Family Responsibility Office, that is to say, every court order that is made in the province of Ontario is by default at law at the time that the order is being issued with the court, necessarily is to be registered or is registered at law with the Family Responsibility Office. If I'm making this very utterly confusing and very vague, I apologize. If we have a court order that is registered with the Family Responsibility Office, a support deduction order form 1 and a support deduction order information form 2 will also be completed and filed with the Family Responsibility Office. We have essentially two orders. We have the original order and we have the support deduction order. That applies in the instance of an agreement and also an order. Set that aside for a moment. If we have a court order that is issued, registered for enforcement with FRO, with the Form 1S support deduction order and information form, and then parties withdraw the court order from the Family Responsibility Office, And while the order is withdrawn from the Family Responsibility Office, the payor defaults on payment. The enforcement mechanisms available to the support recipient would be similar to any other payment order that's in place in Ontario: garnishment of wages, seizure of property, and so on. The Family Responsibility Office has, if let's switch gears into another scenario. Trying to complete this and squeeze this all in 4 minutes is not the most easiest. If we have another situation of where we have a court order or a agreement registered with the Family Responsibility Office, the Family Responsibility Office, in addition to the enforcement powers that a support recipient would have if there is an existence of an order that's not registered with FRO, the Family Responsibility Office can garnish wages, can send notices of garnishments for government benefits and credits that are received, can suspend driver's license, can suspend passports, can incarcerate. The list of the powers that the Family Responsibility Office has are all set out in the Family Responsibility Support Arrears Enforcement Act. For further detailed information about all of the powers that the FRO may have to enforce, I would suggest consulting with the lawyer with Russell Alexander. The quickest way of knowing what those powers are is by reading the index to the Family Responsibility Support Arrears Enforcement Act. So as you can see, there's a number of different instances and scenarios. I have received, over my experience, I've received countless number of files where the client is seeking guidance about registration. We need to, when you're consulting with counsel, we need a copy of the original order and/or agreement. You need to situate your counsel and your legal team, including the clerk, in a position of having that original document. If it's a domestic contract agreement order, whatever it is, they need that as a bare minimum to provide assistance. In addition, if you signed documents and you initially had an order and then it's not currently registered with FRO, you probably signed a notice of withdrawal at some point. You can file a notice to refile the order or the agreement. But if you're seeking advice from a professional legal team about enforcement issues, you should get together the orders, the agreements, whatever as applicable, any documents that you have from the Family Responsibility Office, including the filing of it, the SDO, the withdrawal, the notice of refiling, correspondence. You might have filed and you may have received correspondence from the Family Responsibility Office that has a case file to refile, and your legal team would need to know that FRO number, the FRO case number. Sticking on the enforcement mechanisms and being mindful of the time. In addition, the other things that I would want to share is that there's other enforcement mechanisms such as seizure or garnishment. Um, there could be default hearings. Default hearings are quite complex. I don't think there's enough time to get into those things here. There's attachment to property, and essentially, because of the existence of the family law rules, which set out enforcement mechanisms around rules 26 to 29, I would say, all sort of the enforcement powers, as well as the Family Responsibility Support Orders Enforcement Act, which you guessed it only applies if the order or agreement is registered with FRO. As the takeaway is that, wow, there's a lot of legal mechanisms in place to enforce the order or agreement. And if you're not paying the support in accordance with the order and agreement, at some point it may catch up to you. So it's best to continue to comply with the agreement. But again, footnote, I've seen countless of times where the most unfortunate circumstances happen for no reason or fault of the payor. Sometimes they end up in a situation they're not able to maintain the payments. It's always best to at least pick up the phone, call counsel at Russell, call the intake department at Russell Alexander, and see if you can have a consult of any kind of complicated situation where it seems nearly impossible to make those payments. Circumstances have changed. Give us a call. We'd be happy to walk you through those complex situations.
Mhm.
There is a lot
And
there. I apologize for being so confusing, but
no, you were good. You were good. I just, our next, our registration is open. I'm forwarding this. I normally do it at the end of our session, but next week's event is dealing with FRO and default hearings. So if you do have any questions about that, next week would be a great webinar to turn into. Now we're going to be shifting gears away from, the idea of child support itself, and we're going to be dealing with a subtopic of child support. I know it's been tossed around a couple times today, both what's called table child support and special expenses, or say special and extraordinary expenses. And I'm going to let Pedro discuss that in some detail now.
Yeah, we have talked about Section 7 today. Uh, so let's talk about Section 7 once again. So we often get questions about special or extraordinary expenses, better known as Section 7 expenses. They're called Section 7 expenses because they come from Section 7 of the now cited multiple times through the day, the federal child support guidelines. That's the part of the law that lists which kind of extra costs can be added on top of the regular monthly table child support. So when you hear Section 7, think of it as a second layer of child support for things that go beyond the basics. At least that's how I look at it. So what are Section 7 expenses? As we discussed earlier, table child support covers the ordinary, everyday needs, food, clothing, and shelter, for example. So Section 7 expenses are for the bigger and exceptional costs that are considered both necessary for the child and reasonable given the parent's financial situation. So some of the common examples are, think of childcare costs, daycare, babysitting, medical and dental expenses, educational costs like tutoring or private schools or post-secondary education costs. Think of extracurricular activities such as competitive sports. Joseph is into hockey. Mark likes baseball, and so do their kids. So think of music
And
lessons.
Sonia likes Christmas trees, collecting Christmas
Yes,
trees for the house.
yeah. Think of summer camps, which carry a significant cost. So Section 7 covers the extra that helps the child grow and learn. Think of them as investments in the child's development, the kind of opportunities that truly support their full potential. I say this and I stress on this because many times there is disagreement among parents as to what can be considered a Section 7 expense or not. We're going to touch on this shortly because the key here is communication. So the other point, which both of you have touched on, both Joseph and Sonia have touched on, is the question as to how are they shared? How are Section 7 expenses shared? These expenses are shared between the parents in proportion to their incomes. In proportion to their incomes. That means that if one parent earns, let's say, 2/3 of their combined household income, and the other one earns 1/3, the costs usually are divided in that same ratio. For instance, if the qualifying expense is $900, one parent may pay $600 and the other $300. So it's not a 50-50 split. It's about fairness and the ability to pay. So another question we're asked is what are the judges looking for when looking at Section 7 expenses are in dispute? The judges, they focus on two main questions. The first question is the expense necessary for the child's best interest? The second question would be, Is it reasonable based on the parent's financial means? Judges also look at communication. Was the other parent consulted before the cost was incurred? For example, if one parent enrolls the child, let's talk hockey because Joseph likes hockey, in a $2,000 hockey program without discussing it first, it can become an issue. So courts expect consultation, transparency, and receipts. So good documentation, invoices, proof of income, written discussions, all these things, they always help. So the best practice is simple. Talk first, agree if you can, and always keep those receipts. And I say that because trust me, those receipts are the very ones you're gonna be emailing me if you ever retain a lawyer at Rosa Alexander. So in conclusion, Section 7 expenses cover extraordinary or necessary costs that go beyond the basics, beyond table child support. And they are shared proportionally to each parent's income, with cooperation and communication expected at every step of the way. At the end of the day, both table child support and Section 7 expenses serve the same goal, which is to make sure that the children are cared for fairly and consistently in both households. Back to you, Joseph.
Yeah, thank you, Pedro. That was very, very comprehensive. Thank you. I know we're a little short on time, so I am going to flip it back to Mark to discuss how a person can apply for a change or apply for a support order in general if maybe there's not one in place already. So I'll let Mark take it away on that front.
Thank you. That was very well done. How to apply for or change support orders. And again, the support order can include a written agreement. From a practical perspective, this time, given that we're short on time, I would, one, obtain the document that you wish to change, if it is an order or an agreement. And I would refer to that document to see if there's any guidance as far as the steps that need to be followed in terms of in terms of changing it. What I mean by that is oftentimes there's additional provisions that are added in a written separation agreement that you may not see in a separation agreement, but they're very important because you're contractually bound to follow those steps for purposes of changing this underlying support. Once we have situated ourselves with the process and procedure, then we would, of course, confer with the other side as far as the change that we're seeking to make and provide the evidence that would support the change that we seek. If the other side is non-responsive or there's a dispute about making the change, but you've conferred, then you may be able to either proceed with a fresh application or a motion to change. Again, back to what Joseph said at the outset, it's very complex and the circumstances there's not enough time to get into when we're going to do an application, when we're going to do a motion to change. But at the end of the day, if we can't agree to the change, then we need to proceed and commence court proceedings, quite possibly. When we do that, you'll need to provide, for purposes of the court documentation, preparation of the court documentation, all of the income information, the parenting arrangement details, the existing agreements and orders, and so on. Essentially, say for example, the table support doesn't need to be changed, but the Section 7 expenses need to be changed, but because it didn't deal with the expensive hockey or baseball or expensive Christmas ornament decorations or whatever the case may be, then you have to get all of your receipts, and if everything that Pedro shared all applies in that situation. Let's say if the order agreement doesn't deal with that initially. So in short, how do we apply for or change child support orders? I would say it's a lot of information gathering. and strategizing and determining with respect of a process and procedure to take the steps going forward. And um, once we confer with the other side, if they don't agree or agree, we can proceed as long as it's in accordance with, you guessed it, the child support guidelines that the four of us have outlined throughout the last hour. I think that's all that there is for time on that topic. Back to you, Joseph.
No,
I don't
thanks,
think I
Mark.
did that topic justice, but we're getting
No, I
short
mean,
on time.
we have so many subtopics to get through, and we only have a short period of time to do so. And I mean, as I explained already a couple times, each one of these subtopics we could spend at least an hour discussing in detail. There's really so much knowledge to convey, and we're just barely grazing the surface here with these discussions. But it's more so just to provide you, the viewer, with a basic understanding of these subtopics, and and getting child support in general. So you can have an idea of what to look for in terms of next steps on your specific matter. And with that, I'd like to say thank you so much, both to our viewers on Zoom as well as on YouTube, for tuning into Family Law Now After Hours. After this session, a brief survey will appear if you're joining us today via Zoom, and that will allow you to share your comments and suggestions for future topics that you'd like us to explore. And as always, your feedback is greatly, greatly appreciated. And because you've made it to the end of our webinar today, you are able to book now to take advantage of this opportunity for a complimentary 20-minute initial consultation with one of our lawyers here at the firm. In order to take advantage of this opportunity, please contact our intake team at intake@russellalexander.com. It's two S's, two L's, and be sure to mention our after hours series to schedule your appointment. As I mentioned again previously as well, registration is also now open for our next event, What If Support Payments Aren't Made? And that is in relation to both FRO and default hearings. In order to register, all you need to do is go to russellalexander.com/family law now. Thank you so much to our panelists, Mark, Pedro, Sonia, for you guys sharing your insights today. All such knowledgeable individuals. And again, thank you again, the viewer, for tuning into Family Law Now After Hours. Have a great night, everyone. Thank you.